like Jason said, I do enjoy working. I need the clicker too. Oh yeah, I knew I was missing something. Thank you. I do enjoy working with our portfolio companies on issues relating to corporate governance, which is the topic of this presentation today, the whys and hows of conducting effective board meetings. Jason probably oversold the comedic elements to this presentation. I will tell you that as I was going through I needed to go through my slides last night, but my 9-year-old son was having a hard time going to sleep. I decided to kill 2 birds with 1 stone. I can report that one of the birds was dead after 5 slides. So if you make it past 5 slides, you did better than he did. It is a very important topic, and I wanted to introduce it by referencing someone who is in the news yesterday. But this is a clip from the 2012 presidential election when he got heckled in Iowa by some people who were bringing up his reputation as a vulture capitalist. Let's see if we can play this clip.
For the coming decades, going to be able to balance our budget and not spend more than we take in, we have to make sure that the promises we make in Social Security, Medicaid, and Medicare are promises we can keep. And there are various ways of doing that. One is we could raise taxes on people. That's not the way. Corporations are people, my friend. We can raise taxes on. Of course they are. Everything corporations earn ultimately goes to people. So, where do you think it goes? What? Whose pockets? Whose pockets? People's pockets. Okay, human beings, my friend. So number one, you can raise taxes. You can raise taxes. That's not the approach that I would take. Number 2, you can make sure that the promises we make are promises that we can keep. And in my view, the areas that you have to consider are higher income people.
He did a pretty good job answering the question, I would say. So corporations are people. The law recognizes that to an extent. In fact, in the last few decades, there have been several Supreme Court cases that have extended constitutional rights to corporations, even though corporations are not mentioned in the Constitution itself. Some of those rights include the right against any unlawful searches and seizures from the 4th Amendment, and free speech in the Citizens United case that talked about the ability of corporations to speak through donating to political campaigns. So corporations do have some rights, and relevant to our presentation today, they have a separate legal existence that allows the owners of the corporations to be shielded from liability, which is the key. You don't want to, most business people decide not to run their business as a sole proprietorship or a partnership because there isn't that liability shield that a corporation and an LLC provide. And throughout this presentation, I'm going to talk about corporations, but if you're an LLC, most of this advice would apply to you as well. Some of the terminology is different. LLCs don't have shares, they have membership units. LLCs don't have a board of directors, they typically have a board of managers, but some of the same requirements apply to them. And some of the same consequences can attach to LLCs if they fail to discharge, fail to maintain certain corporate formalities, just like a corporation, including holding at least annual meetings of the board of directors and the shareholders, keeping accurate, detailed records or minutes of those meetings, and especially recording the important decisions that are taken at those meetings, and adopting and complying with bylaws. An LLC would have an operating agreement, but that's kind of equivalent. So, very important to maintain those. The consequences can be very serious. And I should have included on this list also the idea that a corporation has to have a separate bank account in order to justify its separate legal existence. That's one of the big things that owners get in trouble with, is if they commingle funds from their personal and company accounts, then a court may very well decide that the company is really just an alter ego of the owner, and liability will pass through that entity to the owners. So very, very serious consequences, and we want to avoid those by maintaining all of these formalities, including holding regular board meetings. These are kind of the negative reasons to have board meetings. I recognize that, and in talking with founders and officers of companies, it's hard sometimes to get them on board with the idea of having these board meetings and scheduling them, because they feel like it's a distraction from their work. It takes away from their operations. But my goal today is going to be to convince you and persuade you, or at least help you realize a little bit more, that boards should be a value add, and it should be a priority. But to get to that point, I need to talk about, I think, some of these kind of coercive and negative reasons to do it. Another reason that we need to have board meetings is that when someone becomes a director of a corporation or a manager in an LLC, they have fiduciary duties to the company and the shareholders. The first of those fiduciary duties is the duty of care, which basically just means acting like a reasonably prudent person. There's some good legal language. Based on the available information, reasonably available information. There's also the duty of loyalty, which is basically the duty of good faith and fair dealing. An example of when the duty of loyalty comes into play is when a director comes across an opportunity that would be within the scope of the company's business, and the director in that position would be obligated to bring that opportunity to the corporation rather than taking it for himself or herself because of this duty of loyalty. Now, as long as the directors are discharging these two duties, they can be sued, but if they are sued and they're found to be discharging these duties, the court would apply what's called the business judgment rule, which gives directors broad discretion. And the court will basically say, okay, look, you're discharging your duties of care and loyalty. We're going to defer to you that what you did was in the best interest of the company and the shareholders, and we're not going to scrutinize your decisions too much. If, however, the court were to find that the duties of care and loyalty were not being discharged by the directors, then in some jurisdictions, the courts would apply something called the entire fairness test, and it would delve into the basis for the decisions, and it could eventually substitute its own judgment as far as what was in the best interest of the company. So that's obviously undesirable. And a big way that directors discharge these duties is by having regular meetings, keeping informed, being involved in the company. And as long as they do that, they'll get a lot of discretion by any court that has that these issues come before. So we've talked about these negative things and reasons to hold board meetings. It doesn't, of course, guarantee that you won't be sued. Having been practicing law for 16 years now, I've seen plenty of lawsuits that I thought didn't have much basis. And this next slide, but what I want to say here, and I'll say this first of all, board meetings are not funny. They do not lend themselves to humor. Bryn and I tried very hard. So our feeble efforts at humor, please give us some grace on that. What I'm trying to say with this joke, though, is that as long as the directors are discharging their fiduciary duties, as long as the corporation is maintaining those corporate formalities, you're more likely going to have a lawyer like this bring a lawsuit against you. And in that case, much more likely that the risks are lower and the outcome will be quicker and more favorable for you. But I like that, my frivolous lawsuit. The older I get, the more I like dad jokes like that. So let's talk about some more positive reasons, the value add reasons to have a board of directors and to have these regular meetings. Let's talk about the role that directors play in a corporation. These are very important things, obviously. So they attend regular board meetings. At RevRoad, we recommend at least quarterly, because if it's less frequent than that, they might not have enough information to really provide the guidance that they're obligated to provide. If they're too regular, if they're more regular than quarterly, for example, or if they're monthly, the danger is that they're going to get too much in the weeds, too much into the day-to-day operations of the company, which is really not what their role should be. Directors prepare and sign written consents and resolutions relating to major decisions that are relevant to the company. They appoint officers, and they hold those officers accountable. That's key, and they oversee the compensation of those officers. They propose and implement company strategies and objectives, big directional issues. And finally, they make major decisions for the company. And sometimes the kinds of decisions that the directors are supposed to make are set out in some specificity in the bylaws. Does anybody have an example of a major decision for a corporation that really should be taken by the directors and not by the officers alone? Chris?
Major change of ownership or bringing new investment in, major taking on a large sum of debt.
Yeah. Absolutely. Those decisions would have to be taken by the board in almost all cases. Thank you, Chris. Yeah, he said taking on a lot of debt, any M&A activity. Is that a good summary?
Yeah.
Yeah. AJ. Let's get a microphone. Let's get a microphone for AJ.
What about some sort of major catastrophic PR crisis or something the company's going through? Would that merit something with the board?
Yeah, I would think that it might have to be brought before the board. It might not be spelled out in the bylaws that kind of thing would be, but as an officer, you would certainly want to include your directors in any response to that kind of thing if it's really major. All right, thank you. Okay, let's talk about the hows, how to prepare and conduct an effective board meeting. And there's going to be a common theme throughout these things, and it's preparation. Set the meeting schedule a year in advance. Where I'm always bugging our portfolio companies, and Bryn has been helping me with this, which I'm very grateful for. Dates for the board meetings, a year out. Put them on the calendar. Don't move them unless it's an absolute necessity. Make sure, of course, that the directors are involved and that they choose the dates and that they can make it. Create a detailed agenda along with the other officers of your company. Involve them in that, and they can actually be assigned roles at the meeting. For example, a CFO will typically present a financial report to the board of directors at the meeting. Send the board materials to the directors. Most of the guidance I've seen is about a week in advance. Give them all the information so they can prepare for the meeting, so they can provide the specific and well-informed guidance that they want to and that their duties obligate them to provide. Draft proposed resolutions in advance. If you know there's going to be a vote on something big, draft a resolution, send it out to the directors so they can think about it, they can be ready for the discussion with the other directors before the meeting, and again, so that their guidance can be informed and meaningful. Be proactive. Think about what the directors are going to talk about. You should have a relationship with the directors. You should have contact with them between meetings. Know what they're focused on. Know what their concerns are. And provide the information for them that will help them give you the guidance that you need. Prepare an annual calendar of events. Think ahead. When are we going to be making a major hire? When are we going to approve our annual budget? All of those things should be planned ahead and should be discussed well in advance of the board meeting, and they should be ready, and they should be informed that these things are going to be discussed at the meeting. Prepare to discuss executive compensation and any stock option grants. Again, directors get involved in compensation issues for officers, and they need to be heavily involved in those decisions. Designate a corporate secretary. Usually one of the directors themselves should be the corporate secretary to take minutes from at the meeting and present those minutes from the prior meeting for the board's approval. Minutes at a board meeting shouldn't be terribly detailed. Those can be discoverable in litigation, so what you want them to be is a summary of what was discussed. You want them to, of course, include the details of resolutions, important votes, what the results of those votes were, and maybe a summary of what was discussed without getting into, it shouldn't be notes on every little detail that is mentioned at the meeting. Directors don't like surprises. Again, like I said before, you should have contact with your directors in between meetings. If there's some piece of bad news that happens, let them know before the meeting. Don't spring it on them then. You want to get their guidance from them. You chose them to be on your board for a reason. They're there because they're qualified. Let them digest the news and then get their thoughts on it. It's very important that officers make full disclosures to the directors. It's their obligation to do so. Anticipate answers to major questions and prepare your responses. Know what they're going to ask about at the meeting. And again, this is one of my desperate grasps at humor because board meetings aren't funny, but I love the Chuck Norris memes, and this is my favorite one. And I'm giving you this advice about not surprising directors at the risk of displeasing Chuck Norris, who destroyed the periodic table because he only recognizes the element of surprise. That's my favorite one. I really like that one. So this one is probably very intuitive. As an officer, as a founder of a company, when you present information to your board, it has to be 100% accurate. It's especially vital with respect to financial information and your financial report. Mistakes in key information can and will result in a loss of credibility to the officers. And again, the director's role is to hold you accountable. You need to make sure that the information you're providing to them is 100% accurate, or you will lose credibility. It will affect your career. Not good. It's not good. And remember that directors have those fiduciary duties to the company and the shareholders. And if you're giving them bad information, that affects their ability, and it could open them up to liability. Finally, control your entrepreneurial optimism. Most entrepreneurs that I know and I have the pleasure of working with are very optimistic about their ideas, about their businesses. I love it. I love the energy. But in a board meeting, you really need to stick to the facts. You need to recognize that you have this optimism, and you should temper it when you're presenting to your board. So kind of in conclusion on the hows, accept director feedback. It's a gift. All feedback is a gift, as our great CFO often says. Apply it to future meetings. Welcome the fact that they are going to hold you accountable. They're going to remind you of the things that you decided to do and the directions you decided to go in at the meeting, and be grateful for their guidance. So in conclusion, that's the main thing. If you want your board meetings to be effective and to be beneficial to your company, plan ahead, make sure the directors are well informed before the meeting, and recognize that their role is to guide and direct the company, guide and direct you, hold you accountable. And I think that if you do that, you will find that your board meetings are effective and they're a vital part of your success. So with that, if you have any questions, please wait for a microphone, I think, and we'll get them on the stream so that the people that are listening can hear your question.
Just a question on when you would structure your board beyond, say, the original founders. So the way our startup has started, we've got our board of directors are the same people as the officers, are the same people as the executives, are the same people as the founders. So at what point in time is it appropriate to take on additional board members? I'm assuming at an investment round, but is there any other benefits or detriments to doing so at a different time?
Yeah, I don't know that you're required to, but I would recommend doing it very early so that you have that outside accountability and guidance early on. And by the way, if there are others that want to provide feedback on these questions, feel free to. There's no reason that you would have to wait to get a director, especially if you have somebody in mind who you know well, who you trust, and who is knowledgeable in your industry.
So I think the
early
feedback that we had gotten, and the reason we haven't brought on other directors, is the potential loss of control. And if a small team of directors, say our company at the moment of just 2, bringing on an external director early and then getting an investor who wants a director's seat then means we've already lost control of the company. And how does that weigh into that decision?
No, that's a legitimate concern. Your bylaws will probably tell you how many directors are to be on your board. Your bylaws can be revised, and if you feel like you need to add more, you can expand it to 5. Pete, did you want to add something?
I'm just curious. A lot of times, you're the attorney here, so you tell me, but a lot of times I think before push really comes to shove, it's kind of rare, in my experience, to have something in a board meeting come down to a vote and us against them. Usually it's the outside and things like that, but if it really did and it were that big a deal, usually you can wait and override them with a shareholder vote because you hold control there. And so having one board member outside, even in a worst case scenario, it's kind of hard for me to see that causing real lasting damage that you can't get around. What do you think there, Joe?
No, I agree with that, because at a very early stage, which it sounds like your company is, you're likely to have a majority of the shares. You should be holding a shareholder meeting where you will elect or confirm the directors that are on your board. And ultimately, that's where the control is at that stage.
And fire that board member quick if worse came to worse.
Yes. Pete says, fire that board member quick. And that's a good advice from I think, an experienced director. Thanks for that question.
Sometimes a board member will sometimes have a contractually obligated seat that comes with their investment or their participation, so you can't fire them.
Later on, it's true. And when investors come in, when a big investor comes in, they will almost always require a board seat, and that obviously it always complicates things.
Which is different than his early get someone on because you want good advice type of thing.
Yep. Thanks for that question. That's very relevant, I think, to most of our portfolio companies and probably the audience here. Thank you. Any other questions?
Would it be appropriate to bring up board of advisors in this scenario?
Yeah, I mean, early stage companies don't typically have a board of advisors, although a board of advisors can do a lot of the same things and can be a great source of guidance. And and there would be no reason you'd have to consult your bylaws to know whether that's available or not. Pete.
If no one else, I have one more. Joel, I read a good quote in a venture capital blog. I forget who it was, but he said, if you ask your board what color should our logo be and give them time, they'll debate that for 4 hours in the board meeting. I wonder if you have any advice on how to really make sure that you get maximum benefit, because I found that to be true. You can ask the side question that doesn't really matter and they'll spend all their time, or you can get their expertise to really change and affect the trajectory and success of your business. But how do you get maximum benefit and kind of control the agenda so that you're using their great capability effectively?
Yeah, and not with endless discussions of what the logo should look like. Yeah, I think that's where your agenda comes in, and sending out the agenda in advance and having it be detailed, and maybe even having time constraints on each item of the agenda, so that if there is a tangent talking about logos or debating the logo, you can say, well, this has been great, but it's time to move to the next item. And a lot of the times the corporate secretary or the chairman of the board is kind of responsible for maintaining the meeting on that agenda. And that should be an ally of the officers who created the agenda to keep everybody on task. But that's a good question. It's really important not to get into the weeds in a board meeting. Their role is really big picture stuff and not the details. But that's I've seen a lot of board meetings, and that's a real risk. And it makes a board less effective if that's how the meetings go. Anything else? If not, thank you very much. Thanks for your patience with my attempts at jokes.